back to Indianomics and to our discussion on the May 2nd judgment of the Supreme Court, where it held that Bhushan Power should be liquidated after it was acquired by JSW Steel 4 years ago and brought back to life, doubling its profits and revenues. So clearly, India Inc. is in a state of shock, the government is in a state of shock, and bankers and JSW are twiddling their thumbs as to how to take this forward. I have been speaking with Bahram, Vakil, Dr. MS Sahoo, Nalin Kohli and Vardhan of Bain and Company. Gentlemen, thank you very much for your patience and for staying on. Well, Dr. Sahoo, what are the options going forward? Reviews, we are told, don't succeed. But if the government were to implead itself, do you think it stands a better chance?
I think I am least concerned about this specific case or whether a process results in resolution plan or liquidation. My concern is supposing this transaction had resulted in liquidation and the Supreme Court now finds out that it has been tainted, the decision underlying the liquidation was wrongly, illegally done. Could the Supreme Court have undone this transaction? The whole issue is about the finality of the transaction, and it is not limited to insolvency and bankruptcy code. This is telling that any commercial transaction, no matter how long it has been implemented, and no matter how many layers of approvals, state approvals it has got, it remains vulnerable to being overturned ex post. And this creates the uncertainty, and no one would like to invest in a transaction which can be undone by any state agency years or decades later. So the lessons for public policy is actually there are two structural asymmetries. First is the asymmetry about the timeline. Commercial transactions require multiple parties to interact, what they need to do with urgency and coordination. IBC expects that it assigns the COC and the resolution applicant the role of decision maker, entrusts a hierarchy of adjudicating authorities, NCLT, NCLAT, and Supreme Court with approval functions, with resolution professional acting as supervisor. This prescribes timelines for the participants, and courts have held this to be mandatory. But most of the laws do not prescribe timeline for the state agencies or court, and whenever they do, these are considered to be directed. If the market people are required to act swiftly, on time, and bear all the consequences of the decision, penalized for the delay, why can't state agencies be subject to same time discipline?
Three cheers for that.
In this matter, the market participants, under the oversight of NCLT and resolution professional, completed the transaction in 18 months, submitted the resolution plan to NCLT. Thereafter, NCLT, LAT, and Supreme Court have taken 6 years. So market gets 18 months, and it will penalize for every mistake. And the hierarchy of agencies, layer after another, can afford to commit mistakes. NCLT can commit a mistake, NCLT will rectify, NCLT can commit a mistake, Supreme Court rectify, and Supreme Court can commit mistakes also, but it is final, not that it is right.
No, so I take your point, the asymmetry is absolutely blinding, and the consequences are very, very severe. As you put it, for JSW, it's a question of losing like thousands of crores. But for the governmental authorities, whether it is ED or whether it is the courts or the tribunals, there is no loss at all. I take your point about the longer term consequences. I'm just worried about the next steps. Mr. Kohli, that is what I want to know. Is it a review is the only option available, and is that even a hopeful option?
So, I often say as a arguing counsel that, I'm like a surgeon in a court. It's a life and death situation for the litigant. And I often say that, even if you have a 1% chance and if you don't take it, then it's as good as zero. So till a chance exists, you take a choice that I'd like to take the chance or not. So review and curative are the other chances that are there. But they have, the chance of success is limited. However, not impossible. And I'll give you a case. take the DMRC or the Delhi Metro case and the arbitration that took place with Dample, the airport line. You had an arbitration award upheld in the 34 by the single judge of Delhi High Court, overturned by the 37 appeal by Justice Sanjeev Khanna when he was in the Delhi High Court, upheld, and then the 37 reversed. The award comes back into existence in the Supreme Court, and finally, much later, a three-judge bench of the Honorable Supreme Court in the curative overturns the award. So therefore, people would have argued that, excuse me, there's no chance in a review and no chance in a curative. Finally, the curative changed it. So logically, this is a call that only Jindal can take, or the banks can take, or the government can take, whoever. Do they wish to file a review or not? I would give it a fair chance that they may take a shot at review. Fair chance. The second aspect is what would happen at the NCLT. That's the adjudicating authority. Because if the liquidation is kicked in, that is something that is bound to now turn the wheels there, and therefore there will be a set of litigation that has to take place. My third comment, beyond the legal process, and to build on what Mr. Sahoo said, business and the wheels of economy, and also of a civilized society that runs on rule of law, is based that the rules of the game are understood and they're not going to change midstream, and therefore predictability for business environment is critical. At the end of 8 years, the outcome is successful in terms of the running of Bhushan Steel, its acquisition, its doubling its output, people, etc., is very good. If that is changed and brought to naught, it shakes investor business confidence. So that is something which frightens people, and the litigation system is therefore will have to also, while rule of law has to be there, weigh in the consequences of the outcome.
Yeah. No, fair point, sir. I think India's ranking in ease of doing business by this single case perhaps will go down, both in terms of enforceability of contract and in terms of litigation. No two ways about that. But sir, out of time, sorry. I just want to know, Mr. Harshvardhan, God forbid if it is liquidation indeed, could it not go for higher than 19,700 crores? I mean, will the banks really lose?
We don't know. Remember, these appeals and all will take time, and in that time period, the asset would be in limbo. So I don't know when the appeals will be over, because you can't start liquidation until the appeals are over. So I don't know what that timeline would be. There is one way out of the company law, and maybe Mr. Vakil can comment, under a scheme of compromise under 230, Section 230 of company law. I don't know whether it can work here. And there is a debtor-creditor compromise, which again has to go to NCLT. I don't know whether that will work here, but I see that as also one way of probably resolving this.
Okay. Vakil, clearly ball is in your court. You think an out-of-court settlement is a way out?
I think very unlikely. I wish, but I think very unlikely. I think Dr. Sahoo and Nalin have put it so well. Basically, just want to wrap up by saying this is a very severe blow to IBC, and in some ways, as Dr. Sahoo said, to the M&A, situation or ecosystem in totality. If 4 years down the road, this can happen to you, then it really shakes confidence. And if you are a bidder, Latha, domestic or foreign, would you go in for this? Last two quick points. This morning itself, client came in and said, they are about to close in an IBC bidding situation. Said, I need an undertaking that if it's overturned, like what has happened in JSW, I get my money back with interest. In this case, of course, there is no interest undertaking. But now you can see the fear that in every transaction, people are going to ask for undertaking, give me all my money back with interest. And the last thing we have not discussed, but this unraveling, the banks coming back with 19,000 crores, the debt funds, some of them which may have expired by now, how they are going to get the money, the OCs, operational creditors, employees, state corporations, electricity boards. I mean, how can this ever work? It has not been thought through with all due respect.
Okay, fair points, gentlemen. I won't even try to summarize because you guys, you have been so evocative and vocal and convincing in your arguments. Yes, the Supreme Court has to ensure that the law is not disobeyed and taken liberties with, impunity. Yes, but at what cost? The court has to take a public interest view, and let's hope that the options that are on the table in terms of review and curative petition are able to salvage the situation. That's it on this edition of Indianomics. Thanks much for watching.